former chief, jointly also representing the accused. I thank my senior brother for all the submissions. As has notified the court, Your Worship, I'm just only adding a few Ghanaian cases to qualify that his application is dead on arrival. Your Worship, first of all, I'll address you on the decision of High Court. Miscellaneous cause number 87 to save court's time.
The parties?
Uganda Court Reporters Association Limited, Uganda Court Reporters Association Limited against the AG. I'll draw your attention, Your Worship, to page 10.
Read for me the citation first.
It's miscellaneous cause number 87 of 2014. Miscellaneous cause number 87 of 2014.
Okay.
I'll address you, Your Worship, from page 10 to 14. A few highlights court mentioned. One, I'll start with page 11, paragraph 34, which buttresses the point senior counsel has presented that applications of this nature require evidence. You don't come to court and just make an application orally. They require evidence substantiated through affidavits duly administered before the commissioner for oath, and all a witness standing in court and takes oath. You don't come and talk and call that an application. 34, His Lordship is referring, saying that he's referring to Her Lordship was referring to a decision, where it said on line 3 that Justice Maseke DCJ at page 39, referring to the above decision, explained that although the right to obtain justice is not absolute, in each case where derogation is sought,
Although the right to open justice.
Much obliged. That justice explained that although the right to obtain justice is not absolute, in each case where derogation is sought, the court will have to weigh the competing rights of interests. Carefully, with a view to ensuring that the limitation it places on open justice is properly tailored and proportionate to the end it seeks to attain. This is further important. The court is obliged to have regard to all factual matters. We should emphasize that. To all factual matters and factors before it, in order to decide whether a limitation on the right, the right to open courtrooms, passes constitutional muster. She further qualified that in evaluating the competing constitutional claims, premised on open justice on one hand, and in national state security, on the other. The starting point is to recognize the vital, significance of openness of court proceedings and records. You should bring that to the case before you. We don't have factual evidence to guide this court to weigh the competing interests. We only have submissions on the back that the cases of a serious nature, which statement alone needs qualifying by way of adducing evidence. That's why I'm saying the cases, the application is dead on arrival. Under paragraph 38, your worship, of the same decision, 38 on page 12. The last sentence is critical. The court is of the view that to justify an order for hearing in camera, and that is the exclusion of media coverage, live streaming, and so on. To justify an order for hearing in camera, it must be shown that the paramount object of securing that justice is done would really be rendered doubtful. If the attainment of the order were not met. Both the defense team, your worship, and this court have been left in suspense. It is only the state that knows the paramount object. And the empowerment here is mandatory. It must be shown. You cannot do that without evidence or record. paramount
They know the paramount what?
object, because they have not given us evidence, and this court, to know what they exactly mean, they've reserved that to themselves. That's not passing the test of the requirement of an application of this nature. And on page 13, your worship, paragraph 41, the burden senior counsel in submission are talked about has been reiterated there under paragraph 41 on page 13, that the burden of displacing the general rule of openness of judicial proceedings,
The burden of?
the burden of displacing the general rule of openness of judicial proceedings lies on the party making the application, in this case the state. And this is very critical, your worship, I'm reading. And that there must be sufficient evidentiality. It is not on preponderance. There must be sufficient evidential basis from which the trial court must assess the application. And upon which it may exercise its discretion judicially, and upon which it may exercise its discretion judicially. If I pose a few questions to trigger this honorable court's decision. One, where is the sufficient evidence to support this application, if any? Two, what is this honorable court going to use to assess this application in the absence of evidence? Three, who bears the burden to present this evidence? And lastly, in the absence of such evidence, how can this honorable court exercise its discretion? Which of the answers to those questions are very obvious, and my colleague state is already confirming that really this is a non-starter. Lastly, Your Worship, the decision of Still High Court of Uganda, this is High Court of Uganda sitting at Kampala, Commercial Division.
The parties?
We have, Your Worship, their Indian names, allow me to mention only Patel, others I cannot read well. Patel and the 5 others against Patel and 10 others. Your Worship, it is in miscellaneous application number 768 of 2021. 768 of 2021
768
of 2021 of particular contents